Your name, ma'am?
Deasha Penson.
All right, Ms. Penson, you're here today because the state of Florida, we're arrested on a charge of battery. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. This happened at 3723 Vision Boulevard, allegedly. Do you have a reason to go back there?
It's at the BRC, Your Honor.
Oh, that's right, it's here.
Yeah.
So you got to go back there, because you're not going to leave, yeah, all right. And I assume they're not in the same area anymore?
I would assume not. I know when there's usually co-defendants or issues, they make sure that they're separated.
Yeah,
I would
okay.
assume not.
All right. The bond is set in the amount of $500 on that battery. You're not to have any contact with, what was her name? Ricky Smith. All right? If you do bond out, no possessing of any drugs, alcohol, guns, or weapons. I'll appoint a public defender to represent you. Which probably, now, did she have something else? She had a bond on these other things? Hold on a second, didn't she have these? I have 2 CFs on here.
That's what she was already in
This
jail for
one's
when
a
she picked
pass.
up this new battery.
Oh, okay, makes sense. Can't just check yourself in like a hotel.
Your Honor, Michael Taylor is mental health.
As well, Your Honor, could we reset for
Yep.
tomorrow?
Reset them for tomorrow for a possible plea. Your name, sir?
Ricky DeBoth.
Mr. DeBose, you're here today because you're arrested on a charge of possession of cocaine. I have reviewed the charging affidavit. I do find sufficient probable cause. As to that, I'll set bond or stay bond of $1,000. The tampering with physical evidence, I'll be $150, and I'll appoint a public defender to represent you on those cases. Thank you, sir.
Your Honor, Jason Scott is also mental health.
I will waive the appearance, Your Honor.
All right, I do find sufficient probable cause. Stay the bonds as they currently are. Appoint a public defender to represent him.
And Your Honor,
And if he does bond out, no return to, is it 2484 Century Palm Drive? And no contact, there was a guy whose truck that was. Jason Spinney, S-P-I-N-N-E-Y. No guns, no weapons, no drugs, no alcohol. Okay. All right. Zachary Johnson?
Yes, sir.
Are you here for arraignment on, because the state of Florida alleges that you did operate a motor vehicle on the streets and highways of Orange County, Florida, while at the time you did not have a valid Florida driver's license.
State did convey an offer to Mr. Johnson of an adjudication of guilt, credit time served.
Wish to resolve the case today, Mr. Johnson, and be an adjudication of guilt and time served, which also court cost of prosecution would be a total of $306.
Your Honor, I would ask that you appoint, he is currently on probation.
Okay, appoint a public defender to represent him. We'll set that for pretrial in Division
84.
84, it'll be December 19th at 8:45 in Portland, Florida.
Yeah.
We'll be seeing him again.
We'll be seeing you, Mr. Johnson.
Some serious charges. You too.
All right, your name?
Araya Sirak Ogba Mikhail.
You're here today because state of Florida alleges that you did on or about the 12th of October of 2022 in Orange County, Florida, in violation of Florida Statute 810.092, without being authorized, licensed, or invited, did enter or remain on any property other than a structure or conveyance. In this case, it was commercial property at 8849 Exchange Drive, and you did so without, and did defy an order to leave personally communicated to you by the owner or authorized person of the property.
And state did convey an offer of an adjudication of guilt, credit time served, and no return to 8849 Exchange Drive.
And he would like to accept and enter a plea of no contest, Your Honor.
Is that correct? Is that correct? You would like to enter a plea of no contest to this charge? Yes?
He's talking to you, not me.
Is that what you want to do?
On my case, I have already asked all to contact the Florida Senate and Amnesty International. There is nothing I can say about myself, except contacting Florida Senate and Amnesty International. There is nothing I can add about my case.
All right. Do you want to resolve the case today or not?
Yeah, I want to finish it today.
Okay, so you want to enter a plea of no contest then, right?
Yes.
Okay. Are you under the influence of any drugs or alcohol today?
No,
Have you suffered from or been treated for any mental illness in the past?
never ever.
All right. You read over your plea form, understood the rights, and signed it. Do you have any questions for me about anything on this form?
Thank you.
Do you have any questions about anything on the form? No?
No.
All right. You understand, finally, this is punishable by up to a year in the county jail, up to $1,000 fine, and that the entry of your plea would result in deportation if you're not a citizen. You understand all that? Yes?
Yes.
All right, I do find sufficient factual basis. Will judge you guilty of this offense, be sentenced to 55 days in the Orange County Jail. You do have 55 days credit for the time that you previously served. I'll impose court costs and a $50 cost of prosecution. That's a total of $273. And you have to pay that at any point in time in the next 12 months. Little at a time, all at once, whatever you want to do. You'll be released as to this case. Yeah, no return to that address. Also, don't go back to that address at Exchange Drive. I was hearing a different language or something. Your name, sir?
I'm John Billheimer.
All right, Mr. Billheimer, you're here today because the state of Florida alleges that on or about the 7th of November of 2022 in Orange County, Florida, you did in violation of Florida Statute 810.091 without being authorized, licensed, or invited, willfully entered upon or remained on any property other than a structure or conveyance. In this case, it was the Star Child Academy, which is located at 12050 Crystal Commerce Way. And you did so after notice against entering or remaining was given by posting, fencing, cultivation, or actual communication. So this is a trespass.
And we're gonna,
Did convey an offer to Mr. Billheimer of an adjudication, credit time served, and no return.
enter a plea of not guilty, Your Honor. There's competency issues.
All right. We'll accept your plea of not guilty, and we'll set that for pretrial in.
Originating through January 26th at 9 o'clock in courtroom 9C.
Not this Jewett. And your name, sir?
Malcolm Cooper.
All right, Mr. Cooper, you're here today because state of Florida alleges that you did on or about the 16th day of October of 2022 in Orange County, Florida, in violation of Florida Statute 810.0143A, knowingly obtain or use the property of 7-Eleven. This was general merchandise, and you did so with the intent to temporarily or permanently deprive them of the right to the property, the benefit from the property, or to appropriate that property to your use. So this is a petty theft.
Yeah.
And Your Honor, state did convey an offer to Mr. Cooper of an adjudication of guilt, credit time served, no return to the 7-Eleven at 1250 South John Young Parkway. There is restitution in the amount of $632.30, and the cost of investigation to OPD in the amount of $110.08.
And he would like to accept and enter a plea of no contest, Your Honor.
All right, is that correct, Mr. Cooper? You wish to enter a plea of no contest to this charge?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
Read over your plea form, understood the rights, and signed it on the bottom. Do you have any questions about anything?
No, sir. That'll be it.
You understand this is punishable by up to 60 days in jail, up to a $500 fine, and at the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
I do find sufficient factual basis. I'll accept your plea. Be sentenced to 41 days in the Orange County Jail with 41 days credit for time served. Impose court costs, $50 cost of prosecution, Cost investigation of $110.08 to OPD. Impose restitution or order restitution in the amount of $632.30 to 7-Eleven. Finally, I'm going to order that you not return to the 7-Eleven at 1250 South John Young Parkway for a period of 1 year. If you do go back there and the court's made aware of that, you are subject to contempt citation. And I'll give you 18 months to get that all paid off.
Yes, sir. Thank you.
May I approach with the restitution?
Yes. And restitution will be paid first. Okay.
I think we're done.
Your name?
Kiana Davis,
Or Ms. Davis, you're here today because state of Florida, oh, this is no info,
The VOP.
right?
The VOP. Let me double check.
Oh, I put in the case number wrong. That explains it. It's 21. Ms. Davis, you're here today because state of Florida alleges that you violated your probation. That was the probation they were placed on for the charge of battery domestic violence. We'll enter a denial of that and set that for a violation of probation hearing in front of Judge McGinnis in Division 50, and I'll appoint a public defender to represent you.
That'd be January 9th at 9 o'clock in courtroom 4E.
That you're being.
Your name, sir?
Donald,
All right, sir, you're here today because you were charged with a violation of probation, and that was on your violation or domestic violence case. I'll enter denial of that. We'll set that for a violation of probation hearing in front of Judge McGinnis in Division 50, and I will appoint a public defender to represent you.
January 9th at 9 o'clock in courtroom 4E.
Your name, sir?
Terrence Faust,
Mr. Faust, you're here today because state of Florida alleges that you did on or about the 19th of October of 2022 in violation of Florida Statute 806.131B1, willfully and maliciously injured or damaged certain real or personal property. In this case, it was a building, the property of Tyrone Thomas or quick release bail bonds as owner. So it's a criminal mischief charge.
And I enter a plea of not guilty, Your Honor.
All right. Enter plea not guilty for you. We'll set that for a pretrial in Division,
83, it'll be December 19th at 8:30 in courtroom 6C.
all right, and I will appoint a public defender if not previously done so. That's which one, Fouts? All right. No problem.
This is a VOP, they don't resolve them here.
All right, your name, sir?
Terrence Myron Foy.
All right, Mr. Foy, you're here because you been charged with violation of probation, and that is on the battery charge that you previously had. I'll enter denial of that. We'll set that for a violation of probation in front of Judge Johnson.
January 20th at 9 o'clock in courtroom 7C.
And we'll appoint a public defender to represent you.
See the judge for this. Circuit court. The sentence.
Your name, sir?
Thomas Fouts.
Mr. Fouts, you're here today because the state of Florida alleges that on or about the 4th of November of 2022 in Orange County, Florida, you did in violation of Florida Statute 812.0142E, knowingly obtain or use or endeavor to obtain or use general merchandise which had a value of over $100 from Target, and you did so with the intent to temporarily or permanently deprive him of the rights of the property, the benefit from the property, or to appropriate that property to your use.
And we're going to enter a plea of not guilty, Your Honor.
Accept your plea of not guilty, and we'll set that for pretrial in Division 62.
It's going to be January 19th at 1:30.
I'll appoint a public defender to represent you.
Honor, Pierre Henry refused.
And I will waive the arraignment and enter a plea of not guilty, Your Honor.
All right, we'll set that for pretrial, and appoint public PD's already been appointed.
It's going to be Division 81. It'll be January 6th at 9 o'clock in courtroom 6B.
Computer crashed. Your name, sir?
Carlton Jackson.
And Mr. Jackson, you're here today because state of Florida alleges that on or about the 28th day of October of 2022 in Orange County, Florida, you did in violation of Florida Statute 810.091 without being authorized, licensed, or invited, willfully entered upon or remained on any property other than a structure or conveyance, in this case, the Circle K at 8299 Silver Star Road in Orlando. And he did so when notice against entering or remaining was given by posting, fencing, cultivation, or actual communication.
And State Did Command offered Mr. Jackson of an adjudication of guilt, credit time served, and no return to that Circle K.
And he would like to accept and enter a plea of no contest, Your Honor.
So that's what you wish to do, wish to enter a plea of no contest then to that charge? Is that right, Mr. Carlton?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes, sir.
Take any medication for that?
Yes, sir.
And you do understand what's going on here today?
Yes, sir.
You read over your plea form, understood the rights on that, and signed it down on the bottom. You have any questions about anything on either side for me?
No, sir.
You understand this is punishable by up to a year in the county jail, up to $1,000 fine, and at the entry of your plea might result in deportation if you're not a citizen. You understand all that?
Yes, sir.
All right. I do find sufficient factual basis. I'll judge you guilty of this offense. It'd be 39 days in the Orange County Jail with 39 days credit for time served. I'll impose court costs and a $50 cost of prosecution. It's a total of $273, and I'll give you 12 months. You can pay that a little at a time or all at once. It just has to be paid within the next 12 months. And I'm going to finally order that you not return to 8299 Silver Star Road. If you do go back there within the next year and the court's made aware of that, you are subject to contempt citation, which could result in up to 180 days in the Orange County Jail. You'll be released as to this case. Your name, sir?
Morrison.
What was your name? I'm sorry.
Morrison.
First name?
Jermaine.
All right, sir, you're here today because the state of Florida alleges that on or about the 29th day of October of 2022 in Orange County, Florida, you did in violation of Florida Statute 812.0143A, knowingly obtain or use or endeavor to obtain or use general merchandise from Save-A-Lot, and you did so with the intent to temporarily or permanently deprive them of the right to the property, the benefit from the property, or to appropriate that property to your use. So it's a petty theft charge.
And State Did Command offered to Mr. Morrison of a withhold, credit time served, and no return to the Save-A-Lot.
You would like to accept and enter a plea of no contest, Your Honor.
All right, Mr. Morrison, is that correct? You wish to enter a plea of no contest to this charge?
I'll take the withhold adjudication.
Yeah, is that what you want to do? Okay. Are you under the influence of any drugs or alcohol today? Have you suffered from or been treated for any mental illness in the past?
Yeah,
Are you taking any medication for that?
I don't know the name of it right now.
Okay, we understand what's going on here today, you know what this is about? Okay, sure. You wish to, you read over your plea form, understood your rights, and signed it down here in the bottom. Do you have any questions for me? Any questions? No? Okay. You understand this is punishable by up to a maximum of 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen. All right, do find sufficient factual basis. I'll withhold adjudication as to the charge. You'll be sentenced to 38 days in the Orange County Jail. You do have 38 days credit for the time you have previously served. I'll impose court costs and a $50 cost of prosecution. That's going to be a total of $273. And I'll give you 12 months to pay that, whether you want to pay that a little at a time or all at once, as long as it's paid in 12 months. You'll be released as to this case. Your name, sir?
Junior Thomas.
Mr. Thomas, you're here because you're arrested on a violation of probation warrant. And we'll enter a denial of that. It'll be set for a violation of probation hearing in front of Judge McGinnis in Division 50, and the public defender is already representing you.
It's January 9th at 9 o'clock in courtroom 4E.
Your name, sir?
Donald Dante Tosin Jr.
All right, sir, you're here today because the state of Florida alleges that on or about the 5th day of November of 2022 in Orange County, Florida, you did in violation of Florida Statute 812.0143A, knowingly obtain or use or endeavor to obtain or use general merchandise from 7-Eleven, and you did so with the intent to temporarily or permanently deprive them of the right to the property, the benefit from the property, or to appropriate that property to your use. This is a petty theft.
And state did convey an offer to Mr. Toldson of an adjudication of guilt, credit time served, and no return to the 7-Eleven.
We're going to enter a plea of not guilty, Your Honor.
All right, so we'll enter a plea of not guilty for you. We'll set that for a pretrial in front of Judge Bigney. Actually, I don't know what's going to happen with that, actually.
62. PTC will be January 19th at 1:30 in courtroom 12C.
Although my understanding is Division 62 is going away, so I don't know what's going to happen with it. But
So there were.
I don't know.
Or 63.
63, but who's going to be, I don't know. Who knows, you know, who, yeah, you're. So you have a pretrial and keep in contact with your attorney. Yeah, it's another division being siphoned off. Civil cases are going down. Your name, sir?
Leo Bradley, Leo Paul Bradley, third.
Just a sec, let me get back to the other calendar. Mr. Crowley, you're here today because you're arrested on a charge of trespass on property after warning.
And state did convey an offer to Mr. Bradley of an adjudication, credit time served, no return.
And he would like to accept the state's offer and enter a plea of no contest.
Is that correct, Mr. Bradley? You wish to enter a plea of no contest to the charge of trespass?
Sir.
Are you under the influence of any drugs or alcohol today? Have you suffered from or been treated for any mental illness in the past?
Sir.
Read over this plea form, understood the rights, and signed it on the bottom. Any questions about anything on here?
So that's everything.
He has, it looks like he has your signature right there. All right, you understand this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea might result in deportation if you're not a citizen. Understand all that?
Sir.
All right. I will accept your plea. I'll judge you guilty, be sentenced to time served, which is
2 days.
2 days. So 2 with 2. I'll impose court costs and a $50 cost of prosecution. It's a total of $273, and I'll give you 12 months to pay that.
I got that.
Okay? You'll be right. You're released as to this case.
I released today?
And
On
no
this one, if
action
there's
on the
nothing else,
bond.
as long as there's nothing else holding you.
No action on the out on bond, Your Honor. It's a driving while license.
No, I'll leave that where it is.
Appreciate that, thank you.
Yeah. Your name, sir?
Michael Johnson.
Mr. Johnson, you're here today because you were arrested on 2 charges, trespass in a structure and also loitering and prowling. I reviewed the charging affidavits. I do find there's sufficient probable cause.
Your Honor, we were gonna, well, I was gonna argue no PCS to the loitering and prowling. Right here. It appears, based on the 4 corners of the affidavit, he was sitting, if I'm not mistaken.
Well, it's in a room, allegedly a locked room that no one's supposed to be in.
He was, oh, I didn't see the locked room. From what I saw, he was at a business. They are alleging that someone was turning the power on and off. But at the time, when the officers saw him, he was walking and then started jogging once he saw the police. There's no indication that he was loitering or prowling at a manner or time unusual for a law-abiding citizen based on the facts in this particular case. The only thing we have here is that he saw the police and started jogging. And they got him for the trespass on someone else's property. But as far as loitering and prowling, I didn't see any evidence that he was about to commit a crime or in the process of committing a crime.
What about the fact that when he walked away, he was hiding, where it said, "No trespassing, violators will be prosecuted," walked the fence line and could see the feet of the male sticking out from the side of the residence as he was attempting to hide by laying down. When I went to go to him, I observed him attempt to crawl under a black pickup truck in an attempt to hide from me. Wouldn't that be enough? State, yeah.
Your Honor, I'll leave it within your reading.
He wants to, that's fine, Your Honor. He'll take the state's offer. That's the both.
Okay.
We did convey an offer to Mr. Johnson of an adjudication credit time served, no return to the residence, or 426 South Central.
All right, so you wish to enter a plea of no contest to that then, Mr. Johnson?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol today?
No,
Have you suffered from or been treated for any mental illness in the past?
no, Your Honor.
Read over your plea form, understood the rights, and signed on the bottom. Do you have any questions about anything on either side for me?
Your Honor.
You understand that these are punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your pleas could result in deportation if you're not a citizen.
Okay.
All right, do you find sufficient factual basis? I'll accept your pleas as to the trespass. You'll be sentenced to 2 days in the Orange County Jail with 2 days credit for time served. As to count 2 days in the Orange County Jail with 2 days credit for time served. Those sentences run concurrent with one another. I'll impose court costs and a $50 cost of prosecution, and you can pay that within the next 12 months. Finally, I'm going to order that you not return to 426 South Central Avenue. If you do return there within 1 year, you are subject to a contempt citation. And what was the other address, State?
It was whatever the address,
Let's see, what was the house?
I don't think they write,
5th Street.
13 East 5th?
13 East 5th Street, if you go back there also, with the next year.
All right.
All righty, thank you.
And Your Honor, he
No
does-
action on the other, on the bond case since he pled. Okay. Your name, sir? Mr. Holloway, you're here today because you're arrested on a charge of disorderly conduct. I have read the charging affidavit, and I do find that there's sufficient probable cause.
And state did convey an offer to Mr. Hardaway of an adjudication credit time served.
And he would like to accept and enter a plea of no contest, Your Honor.
All right, Mr. Hardaway, you want to enter a plea of no contest with time served, is that right?
Yes, sir.
All right, are you under the influence of any drugs or alcohol?
No.
Have you suffered from or been treated for any mental illness in the past? Read over your plea form and understood it. Do you have any questions for me, anything on your side? All right. Understand this is punishable by up to 60 days in jail, up to a $500 fine, and at the entry of your plea would result in deportation if you're not a citizen. Understand?
Yeah, all right.
All right, I'll accept your plea. I'll judge you guilty of that. You'll be sentenced to 2 days. Is that right, 2 days?
Yes, sir.
2 days with 2 days credit for time served. I'll impose court costs and a $50 cost of prosecution, and I'll give you 12 months to pay that off. Okay, thank you.
Your Honor, Breland Garrett bonded.
You already took that out, didn't you? No? I had Trevin Allen next.
Bonded as well.
Bonded, all right. And Chance Biles Johnson. I don't know what that name was that she said then. We didn't have a sheet for that. Oh, so whatever. I don't know, it's the one before.
Was it Allen? You
It
said
was, it was before that.
Oh, okay, thank you. Okay.
All right, Mr. Biles Johnson, you're here because you're arrested on a charge of possession of cocaine. I have reviewed the charging affidavit. I do find sufficient probable cause. Bond is set in the amount of $1,000, and I will appoint a public defender to represent you.
Thank you so much.
It's the attorney's number.
Your name, sir? Mr. Collins, you're here today because you were arrested on a charge of possession of cocaine. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. I'll state bond in the amount of $1,000. You are currently out on bond for another possession of controlled substance. And I'll revoke that bond. I'm just going to increase it to $5,000. And I'll appoint a public defender on the new case. Your name, sir? All right, sir, are you here today because you're arrested on a charge of burglary of a dwelling and criminal mischief? I have reviewed the charging affidavit. I do find that there's sufficient probable cause. The bonds are stated as current burglary of dwelling, $5,000. The criminal mischief is $150, and I'll appoint a public defender to represent you. If you do bond out, you are not to return to 207 North Lee Avenue, and you're not to have any contact with Michael T. Jones. Also, don't possess any guns or weapons or any drugs or alcohol.
Afternoon, Dwan Dennis.
All right, Mr. Dennis, you're here today because you were arrested on a charge of burglary of a occupied structure and criminal mischief. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. Stay the bonds, $5,000 on burglary of occupied structure, criminal mischief, $100, and I'll appoint a public defender to represent you.
Your Honor, state would ask for no return, no contact.
And no, yeah, also, if you do bond out, you're not to return to 6510 West Colonial Drive. And you're not to have any contact with your co-defendant Demetrius Odom or Carlos Aviles, Avilia, Avilua. All right, thank you.
Your Honor, Joseph.
And I will waive the appearance, Your Honor.
What was that? Oh, Gray, okay. What happened with Ricky DeBose? You already did him, right? All right, Latique Gray.
Your Honor, this is a first-degree felony that's punishable by life. State's requesting that you stay it at no bond with no contact with the victim or the co-defendants.
All right, I will stay that at no bond, no contact with the victim or the other two co-defendants in the case. No guns, no weapons, no drugs, no alcohol. And he's out on bond on the grand theft. I'll revoke the bond, no bonds. Your name, sir?
Jeffrey Lee Hawk.
Mr. Hawk, you're here today because you're arrested on a charge of possession of a controlled substance. I have reviewed the charging affidavit, and I do find sufficient probable cause. Let me find out exactly. I think it was meth.
It's a no.
The bond's $1,000 on that. It was actually an arrest warrant from Judge Lattimore. You were also currently out on bond in 2 cases. One, fleeing, attempting to elude and resist an officer without violence, carjacking. When we revoke that bond, there'll be no bond on that.
And it was only, count 1 and 2. Count 3, the carjacking, there was no action
Okay.
taken.
Whatever that is. Also, we're out on bond in 2022 CF 12067AO, possession of controlled substance, drug paraphernalia, and resisting. Revoke that bond, and there'll be no bond on that as well. Want a public defender in whatever cases you don't have a lawyer yet.
Your Honor,
Yep.
and since it's a warrant, the dates, he wasn't out on bond at the time.
1 second, I'll double check.
Just filed on this charge. I was out on bond. I bonded out and they filed on the charge. They had an on 33-day motion for the possession. But I bonded out on the rest after the 33-day motion.
The possession of controlled substance.
June 18th is when what the affidavit says for the case that he was.
They had on 33-day motion for it.
And then the 12067 out on bond is 10/16. And then the 4597 was April. So the 4597 can be revoked. However, state would request no action on the 12067.
Okay, so the 12067 is the possession of controlled substance one.
Yes.
All
The
right, so that I'll take no action. And the other one I will, the one that was from April. So one was, you were out on bond.
Just check the date.
he fails to appear and they revoked him.
Oh, because he failed to appear?
Okay, what are we waiting for?
Nothing, I'm done.
Yeah, we're all
Yeah,
set, thank
He's
you.
gonna have to call the attorney.
Your Honor, Jonathan Hernandez's behavior.
All right, you waive on that one?
I will waive, Your Honor.
All right, in Mr. Hernandez's case, I do find probable cause to bond on the new possession of methamphetamine, $1,000. And on the matter that he's out on bond on, which is another possession, I'll revoke that bond. No bond.
Your Honor, given that that's not filed yet, will you revoke and double?
Yeah, that's what I'll, well, he's ROR.
Will you, it originally came in at 1,000, 150, and
Right.
100, so 2,500.
Okay, we'll do that.
Thank you. It was originally 1,000, 150, and 100. Now I guess it'd be 2,000, 300, and 200.
Yeah. 1, 2, 3, counts 1, 2, 3.
Freddie Hopkins, he bonded.
Bonded.
Deanna Martino is behavior.
That will waive, Your Honor.
All right, we'll stay the bonds on Ms. Martino. I do find sufficient probable cause and appoint a public defender. All right, name, sir?
Charles McClain.
First name?
Charles McClain.
All right, we got two different cases. First of all, in 2022 CF 14058AO, you're here because you're arrested on 3 charges: possession of firearm by a convicted felon, possession of cocaine with a weapon, and carrying a concealed firearm. I have reviewed the charging affidavit. Do you find there's sufficient probable cause? Stay the bonds $5,000 on possession of firearm by a convicted felon, $150 on possession of cocaine with a weapon, and $150 carrying concealed firearm. And then we have 2022 CF 13848AO, And this is from an arrest warrant.
And Your Honor, it is a PBL, so it would ask that you stay at no bond with no contact with the victim or
And this was an arrest warrant for an attempted first-degree murder with a firearm. There is no bond on that, and it will appoint a public defender in that case as well. If he, yes, no weapons, no guns. Yeah. 24 hours. Your name, sir?
My name is George Moore.
All right, Mr. Moore, you're here today because you're arrested on a charge of robbery with a deadly weapon. I have reviewed the charging affidavit, and I do find sufficient probable cause.
And Your Honor,
This is Mr. Gray's co-defendant, isn't it?
one of them, yes, Your
One
Honor.
of
So it would request that you set it at no bond with
Yeah.
no contact.
There will be no bond on that charge. I'll appoint a public defender to represent you. You're to have no contact with your co-defendants in this case, and also no contact with,
George, I had, may I speak?
that's Lateef Gray and Devon Walker, and then also you're not to have any contact with Mr. Sheffield, right? Yeah. Lavon Sheffield is the alleged victim. Appoint a public defender to represent you.
That's the law.
All right, come on up. Your name, sir? Your name? Mr. Morris, you're here, first of all, because you're arrested on a arrest affidavit, or excuse me, a arrest warrant from probable cause, in that charging with fleeing, attempting to elude, and driving while license suspended. As to that case, in the fleeing, attempt to elude, I'll set bond in the amount of $2,500 and stay the bond on the other charge. And if you do bond out, you're not to operate a motor vehicle on streets and highways of Orange County, Florida without a valid Florida driver's license. And let's see, the other. And in 2022 CF 14072AO, you're here because you're arrested on new charges of possession of burglary tools, resisting an officer without violence, and loitering or prowling. Bond set in the amount of $500, $500, and $250 in those, and appoint a public defender to represent you.
Your Honor, state we just asked for a no return to the Gallignol Drive.
No return to that address. All right, you're all set.
Your Honor, Demetrius Odom refused.
And I will waive the appearance, Your Honor.
In Mr. Odom's case, I did find sufficient probable cause. And we will, as to the burglary of structures, bond $5,000, $100 criminal mischief. And he's currently out on bond in 2022 MM 448, looks like 4486, maybe AO.
4486.
Burglary. All right, revoke the bond, no bond on that. Appoint a public defender in the new case.
And count 2 was a nolo pros.
Okay.
You just doing the,
That's just the first count.
okay.
Are your name, sir?
Alex Rivera.
Mr. Rivera, you're here today because you're arrested on a charge of fleeing, attempting to elude a law enforcement officer. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. Set bond the amount of $2,500. Order that you not operate a motor vehicle without a valid Florida driver's license, and I'll appoint a public defender to represent you.
Your Honor, Luis Rivera is medical.
And I will waive the appearance.
You find sufficient probable cause, Mr. Rivera will bond $1,000. Point of public defender. Your name, sir?
Arthur Lee Roebuck.
All right, Mr. Roebuck, you're here today for a new charge. You're arrested on a charge of possession of cocaine. I do find sufficient probable cause. Bond is $1,000 on that, and the public defender will be appointed to represent you in that. You're currently out on bond.
No, sir.
ROR.
Has a state, I don't.
Let's say no bond, no A. Was it, what?
7892 is not filed yet, and that was from July. So state would request no action on that one.
Okay.
On 9968, the arrest was September off of an arrest warrant. Also, no information has been filed, so state would request no action.
And then,
And on 22 CF 10941, the sale and delivery, the arrest was September 19th, and still no information has been filed, so state would request no action on all three.
you're lucky. All right. Public defender will be appointed on your new case. Your name, sir?
Master Rutherford.
I'm Mr. Rutherford. You're here today because you're arrested on a charge of robbery with a firearm and aggravated assault with a firearm. I have reviewed the charging affidavit in the case, and I do find that there is sufficient probable cause. As to the robbery with a firearm, there is no bond on that. Upon a public defender to represent you, if you do bond out, I'll require that you have, don't return to that 1601 South Kirkman Road address, and you're not to have any contact with Jaleel Jordan, Jaleel Jordan. State want to be heard as to the aggravated assault.
Your Honor, he is entitled to a bond on that. State would be requesting a reasonable bond. It is an F3, so something in keeping with it being an F3.
All right, I'll set a bond amount of $1,500 on that, same conditions. Again, a public defender is appointed. Name, sir?
Tyler Seithel.
All right, Mr. Seithel, you're here for a number of things. First of all, you're arrested on a charge of possession of cocaine. I have reviewed the charging affidavit, and that does appear that there is probable cause. Bond set an amount of $1,000 on that. Appoint a public defender to represent you. Next, there was in 2022 CT 1572 AE, a charge of driving while license suspended. I do find sufficient probable cause for that. It's up on the amount of 750, or I think it's 500, isn't it? What did they say? Yeah, 500. Want a public defender to represent you on that. And then finally, there was, is there 2 counts on that?
On the
That's in the MM case, yeah.
Next,
In 2022 MM 301 AE, false information and possession of drug paraphernalia, you do find sufficient probable cause on that. Stay those bonds. Appoint a public defender, and then finally, there is, that's it, right?
Yes.
yes.
All right.
Your Honor, Marcus Stewart bonded. Daquan Walker reviewed.
I will waive, Your Honor.
All right, Mr. Walker is the third co-defendant. There'll be no bond on that. He's not to have any contact with anyone of the other 2 co-defendants or the alleged victim in the case. No guns, no weapons, no drugs, no alcohol. Has that petty theft been filed on?
1 second, Your Honor. Not yet, but he only picked it up 6 days ago.
All right, so I'll take no action on that. Your name, sir?
Brady Williams.
All right, Mr. Williams, you're here today because you're arrested on a charge of grand theft, 3rd-degree motor vehicle, possession of methamphetamine, possession of drug paraphernalia, I have reviewed the charging affidavit. I do find that there is sufficient probable cause. The bonds in that case would be $1,000 on the grand theft, $150 on the methamphetamine, and $100 on the paraphernalia. I will appoint a public defender to represent you on that. Looks like the other grand theft was filed on.
No. It was 11/4. He was arrested and it has not been filed.
All right. We'll take no action on that then, since they haven't filed on it. So the other ones, the bonds will stay in place. And a PD has been appointed to represent you on your new case.
Thank you.
These guys are getting second crimes too quick. Your name, sir?
Billy Wright.
All right, Mr. Wright, you're here today because you were arrested on a charge of possession of cocaine, possession of methamphetamine. I have reviewed the charging affidavit. I do find that there's sufficient probable cause. Bonds will be $1,000 on count 1 and 2, so the same thing, $1,000 and $1,000. And I appoint a public defender to represent you. What's that? Yeah. I'll just go back in the back and in the back when you're ready. Okie dokie. I think y'all were appointed yesterday. Are your name, ma'am?
Michelle Crowley.
All right, ma'am, you're here today because you're arrested on a charge of aggravated battery with a weapon, domestic violence. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Is there anyone here on this case? No. Are you, do you have another place to go other than 1466 Mercy Drive?
That's my daughter's house where it's from.
Okay, so you have another place to go to stay?
I can probably go to my father's house. He stay on 819 Polk. I think it's over there by Polk Street.
Okay, all right.
I could probably go and stay there, sir.
All right, what I'll do is I'm gonna set a bond in the amount of $500. Order that you not return to that address. You gotta go live with someone else. You have to have a separate residence.
Okay.
Okay?
Your Honor,
And you're not to have, hold on a second, you're not to have any contact with, Louis Grow, Greaux. Can't have any contact with him for right now, okay?
yes,
Now,
sir.
you can go back to your residence, to your daughter-in-law's place if you have any items there, but you
Yeah.
have to take law enforcement with you, and you can only go one time.
Okay.
All right, no guns, no weapons, no drugs, no alcohol.
Yes, sir.
All right, and the public defender's already been appointed, so you have a lawyer already.
All right, thank you.
Somebody want this, they start saying they wanted these printed out.
Okay.
I mean, it's fine, because I just thought, I can always go off this. Although, I guess I don't know. Are your name, sir?
Jeremiah Shelton.
This also looks like a PD case. Why is he here today? This is the one where they wanted it, okay. Did you guys get anything additional on count 2 and 5?
No, Your Honor.
All right. All right, she set bonds on everything else, right, yesterday?
Yes.
All right, then I'll just ROR them on counts 2 and 5. And everything else remain the same. Public defender is appointed in your case, so you do have an attorney. There was the 2 counts, and I assume what her problem was, although there's a citation that's in the file that indicates that he was a habitual traffic offender. But there wasn't anything to do with the burglary tools. I do agree with that. So I will ROR you on those 2 counts, and the bonds that were set yesterday by Judge Bigney will remain in place on the other counts. Okay? All righty. Your name, sir?
Ron Chisholm.
All right, Mr. Chisholm, you're here today because you're arrested on charge of battery domestic violence. And it was aggravated battery domestic violence on a pregnant person. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Is there anyone here on this case? No. Do you have another place to go and live other than the Wickrow Avenue?
Yes, sir.
Where's that?
My mom in Claremont, 1620 Westminster Trail.
All right, set bond amount of $750. You'd have to have any contact with Samantha Rosa. No contact with her. You can return to that address one time, and that's the 6904 Wilco Drive, number U305. You can go back there one time with law enforcement to pick up any personal items, but you can't go any other than that. And again, no contact whatsoever with Ms. Ramos Rosa. No guns, no weapons, no drugs, no alcohol. And I will appoint a public defender to represent you.
Oh, I'm just in them.
All right, good morning. Your name, ma'am?
Good morning.
Your name?
My name is Sharon Glasgow.
Hi, Ms. Glasgow, you're here because you're arrested on a charge of aggravated assault with a deadly weapon, domestic violence. I have read the charging affidavit, and I do find there's sufficient probable cause. And I know, I guess you were living at you're living at the 1808 address, and this sort of stemmed from you wanting your, I think, son, is that right, to not be there anymore?
Oh, no, sir.
Oh, I'm thinking of a different case, sorry. Do you have another place to go other than the 1808 Grand Avenue address?
No, sir.
Oh. Raise your hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got.
I do.
Your name?
Charles Rowe.
And do you live at the 1808 address?
I do.
What do you want to tell me?
Well, this is my wife. Things got out of hand. And I'm just trying to fix this.
So, do you have any fear of her?
I do not.
So you wouldn't have any problem with her returning home?
I do not.
Now, you understand, it can't protect you. You know, I could order that she not return there and she not have any contact with you.
I understand that.
But you're okay with that?
I am.
All right. She doesn't call for a PTR. All right, I'll set bond in the amount of $500. No hostile contact. So that means she can't raise her voice, she can't pick up anything or throw anything at you, nothing like that, okay? No hostile contact. So you can't have contact, but it can't be hostile, all right? No guns, no weapons, no drugs, no alcohol. We'll appoint a public defender to represent you. Okay? Thank you, sir.
Thank you.
Right there. Your name, ma'am?
Marina Gutierrez.
All right, ma'am, you're here today because you're arrested on three things. First of all, battery by strangulation, domestic violence. Count 2 is battery, domestic violence. Count 3, assault. I have read the charging affidavit, and I do find there's sufficient probable cause. I do have a question about the assault, because in the charging affidavit indicates that the woman was walking away and her back was turned, and there's nothing indicating that she actually saw the raised chair.
They saw the same thing, Your Honor.
All right. But I see we do have two people here, and I have an idea who they might be. Raise your right hands, please. Solemnly swear testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, your name on the left in the green?
Janice Acosta.
All right, and on the right?
Jessica Al-Khatib.
All right, and you two are the alleged victims in this case, is that right?
Yes.
Okay. And do you guys live at 4355 Fountain View Lane?
Yes.
Both of you?
Yes.
She doesn't live there, or she does?
Yes.
She does too. All right. So tell me what you want me to know. Is it okay for her to come home, or you do not want her to come home?
No, we would like to try and get some kind of restraining order. This is not the first episode. This is about the 5th or 6th with me. I did bring paperwork of her psychiatric history. It's in the car, but they wouldn't allow us to bring it. She's done this to many other people before. She has a problem with alcohol abuse, border personality disorder, depression, and many other things.
Okay.
And
All right,
it's just getting
ma'am,
to
do you have another place to go?
I don't. My family stays in Wisconsin. We just moved here.
Well, you're gonna have to find somewhere, because you can't go back there, okay? I'll let you go back there one time with law enforcement to pick up any personal items you may have there, but you can't actually go back there and live. You have to maintain separate residences. Okay, so you're not to return to 4355 Fountain View Lane, and you're not to have any contact with Ms. Acosta, Janice Acosta, or Jessica Alcatab, okay? Or
Is there anything that can I just state something? I do worry about her psychological health. So if you guys could just please keep an eye on that. And I'm willing to even like bring paperwork because she needs a little bit more help. And she also did threaten to take her own life, and she has in the past as well.
Well, if you have any knowledge as to that, if she makes threats such as that, you can always call and have her Baker acted if you think that's gonna help, but it has to be recent. So you're not to have any contact with them. She does qualify for pretrial release. I can set a bond for you, ma'am, or I can release you pretrial. The pretrial release program, there's some conditions that go along with that that are not the same as on a bond, but that's up to you. But you won't have to post a bond. They'll just talk to you, and then you'll have to check in with your PTR officer. But you won't have to pay any money. What would you rather do, a bond, or do you want to have PTR?
Is PTR to stay longer here in court?
No, you're good. I'll set a bond of 500, you can post that bond and get out, but there will be conditions, or you can go PTR, which is no cost. You won't have to post a bond, but there are conditions you have to check in with your officer from time to time.
I'll go with the program.
Okay. I'll release your PTR. Again, no contact with either the two ladies here. You're not to return to 4355 Fountain View Lane, apartment 7308. You can go one time with law enforcement, okay, to pick up any personal items. That means like toiletries and clothes, not TV and furniture, okay? No guns, no weapons, no drugs, no alcohol, and I will appoint a public defender to represent you.
Thank you, sir.
All right, thank you, ma'am. So she's not to have any contact with you. If she does, that's a violation of her condition of release, okay?
Okay, thank you.
All righty. Your name, sir?
John Rocha.
Mr. Rocha, you're here, and actually, I'm gonna release her, I'm gonna ROR on the assault count, but the bond's on the, TR on the other two. Okay, Mr. Rocha, you're here today because you were arrested on a charge of battery, domestic violence by strangulation, and simple battery, domestic violence. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Is there anyone here on this case? I don't see anyone. Were you living at the 412 Field Stream West address?
Yes, sir. Yes.
Who else lives there?
My girl, Leslie.
Okay. Do you have another place to go?
Yes.
All right. Because you can't go back there right now. All right, I'm going to order you not go there. I'll set bond on the battery by strangulation, 500, battery domestic violence, 500. You're not to return to that address. You can go back one time with law enforcement. So if you call a law enforcement agency, they'll go with you and get your clothes, your personal items, no furniture or TVs, but you can take stuff that you need for your day-to-day. You're not to have any contact with Leslie. Okay. And also, is DCF involved?
Yes.
All right. In addition, you're not having any contact with Leslie. I don't see what's her last
I
name.
believe it's Canales Mondragon.
Yeah. No contact with her. Also, in addition, a condition will be that you abide by any order or program or plan that's put in place by DCF, because I know you guys have a child together. So they've been called, all right? No guns, no weapons, no drugs, no alcohol. And I'll appoint a public defender to represent you.
Quick question.
Sure.
Can this no contact order be used as means to get off the lease? Because we both share the lease. And if I no longer wish to live with her.
You're gonna have to contact your landlord about that. It's up to them. I don't know what the lease reads. It's gonna depend on what the actual language of that lease are.
Is there like a specific document that could basically grant me that you guys can give me, that I can give to my landlord aside from that? Or
Not
no?
that I know of, no. I mean, that's a contractual matter between you and your landlord. Okay? All right, good luck.
Thank you.
Your name, ma'am?
Crystal Shiver Leahy.
Okay, this is the one I was thinking of. All right, ma'am, you're here today because the state you were arrested on charge of aggravated assault with a firearm, domestic violence. I've read the charging affidavit, and I do find there's sufficient probable cause. This is the one I was thinking about before. And I know this sort of stemmed from, is it your son?
Yes.
Yeah, at the house, and you wanted him to go, and you didn't want to go, and so things potentially got worse from there. Do you have another place to go other than 1207 West Cayley?
Honestly,
Friends, family, somewhere else?
I don't, because I also work from home.
Well, here's the problem, because I can't let you go back there for right now if he is there.
He's leaving tonight at 8 o'clock. He has.
Well, and that's fine, but for right now, what I'll have to do is say that you're to maintain a separate residence from Christian.
Can I pay for him to be an extended stay if he comes back into the state?
I would think so.
And I can,
But you're not to have any contact with him,
okay, my
okay?
husband can.
But you can do that through your husband, right?
Yeah.
So no contact with Christian, and his last name is also the same?
Ivor Eliason.
Okay. No contact with him. You cannot return, you must maintain a separate residence. You cannot return to 1207 West Cayley if he is residing there. All right, so if your husband finds another place for him, I don't have any problem with you returning there, okay? Unless and until that happens, you can go back once with law enforcement to pick up any personal items you may need. For example, if you need something for your work or whatever. But if your husband handles that beforehand, then okay, that's fine. Okay? I'll set bond amount of $750. I'll appoint a public defender to represent you. You're not to possess any guns, weapons, or drugs or alcohol. If you go back there, those guns need to be out of the house.
Yeah, I told them to, my aunt is gonna come get them.
Okay, perfect. You don't have to sell them or anything, but they just can't be around where you are.
Right.
Okay, any questions?
No, not at this.
All right, keep in contact with the public defender's office, all right? That information has had to call them on there, okay? All righty, thank you. Your name, sir?
Nicholas Wright.
Mr. Wright, you're here today because you're arrested on a charge of battery, domestic violence. I've read the charging affidavit. I do find that there is sufficient probable cause. Let me get the, hang on, I'm in the wrong file, just a sec. Come on, here we go. All right, Mr. Wright, do you have another place to go other than the Kirk Street address?
Sir.
Where's that?
Oh, in the pop here.
Okay. All right, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
Your name?
Nicole Lewis.
All right, and you are the alleged victim in this case, is that right?
Yes, sir.
Okay. What do you want to tell me?
It was an argument that kind of got out of hand, but it really didn't get physical. I mean, he tossed around some baby powder, and that's where it went. I didn't see where that was,
All right, now, in here, you were in the process of moving out, is that right? Or had said you were going to move out or something along those lines?
Yes, correct.
And are you still at the Kirk Street address?
Yes, sir, because I take care of his father-in-law, my father-in-law.
Okay. And what would be your position about him returning back to the Kirk Street address if you're living there?
I think it's best.
Honestly, tell me.
Right now, I'm trying to separate, so,
So no? You'd rather he not be there?
I just don't want no animosity. I don't.
Sorry, what did you say?
I don't want any animosity between us.
Okay, I understand that, but that's not my question. I can order that he not have hostile contact but return, but if you think that that's not wise, you think that there's gonna be a problem if he does, I'll just have him, he said he has another place to go, I'll just tell him he can't go back there.
I understand that. I'm not saying that he can't go back there. I'm not.
Okay. So you're okay with him returning to the address and living there?
as long as there's no hostile contact.
Okay. All right, you understand that?
Sure.
Okay, if you do anything hostile, and throwing baby powder would be considered hostile, okay? Regardless, they allege that there's something more, but the bottom line is, you can't raise your voice, you can't throw anything, can't throw any water on her, can't throw baby, nothing, okay? That's hostile contact, you understand? Anything like that?
Yes, sir.
Okay. All right, I will set bond in the amount of $500. No hostile contact with Nicole Lewis. You can return to the address. You're not to possess any guns or alcohol, no drugs, no weapons. All right, and I'll appoint a public defender to represent you.
Your Honor, he also has an on view.
Oh, that's right. That's the one that I clicked in first.
A sale and delivery and weapon, I believe, charge.
Yeah.
I believe it was trafficking and,
Yeah, it looked like it was a trafficking case.
and operating a chop shop.
Sir.
They want to be heard.
Given that it is a VOP and it was placed on it 2/23 of 21, state would request that you set it at no bond until a VOP affidavit can come through, and it'll be set for VOP court within the next few days.
Yeah, I'm gonna, there's a violation of probation. I'll set no bond on that for right now. Appoint a public defender on the VOP as well. So he's not going to be coming home because of the violation of his probation, but there may be at some point, he may get a bond on that. If he does come home, all of the stuff I said still applies to the bond on your case.
Okay.
Okay? All right. Your name, sir?
Ma'am,
I'm sorry, ma'am?
Diamond Andrews.
All right, Ms. Andrews, you're here today because State of Florida alleges you are that you were actually arrested on a charge of battery, domestic violence. Let me get this thing to work. There we go. Back to the top. I have read the charging affidavit, and I do find that there's sufficient probable cause. And nobody's here. Do you have another place to go other than the OBT address?
Yes, sir.
Where's that?
The 5422 Glen Lake Lane.
Okay, and who's that with?
That's my best friend.
Okay, all right. Is DCF involved in this case? Do you know?
Yes.
Okay. All right, I'll set, now I can set a bond of $500, you can bond out. Or I can release a PTR, you qualify for PTR. There are conditions, and you gotta stay in contact with the PTR officer, but you won't have to actually pay any money to get out. Is that what you wanna do, or you wanna go with the bond?
ETR, please.
All right, I'll release the PTR. You're to have no contact with Jaquan Edwards, all right? No contact with Jaquan Edwards. Do you have any items at the Eugenia court address that you need? Any clothes, toiletries, anything like that?
No, sir.
Okay, so you're not to return there or go there at all. And also, you're finally, if DCF enters an order, a plan, or in any way is involved, you're to follow whatever their requirements are as well, okay? No guns, no weapons, no drugs, no alcohol, and I will appoint the public defender to represent you. Keep in contact with your lawyer. Okay. different.
This is the one that the victim is Spanish.
All right.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
All right, good morning. We do have a witness who needs to be, have interpretation in an IA, so we'll just have to guess do it over the overhead, okay?
Yes, Your Honor, certainly.
All right, ma'am, please raise your right hand.
Señora, por favor, levante su mano derecha.
Do you solemnly swear the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Usted jura solemnemente o afirma que el testimonio que usted dará en este caso será la verdad, toda la verdad y solamente la verdad ante Dios.
Sí.
Yes.
And your name, ma'am?
Su nombre, señora, despacio, voz alta.
Caterín Hernández.
Caterín Hernández.
All right, sir, your name?
Su nombre, caballero.
Jason Argueta.
Jason Argueta.
All right, Mr. Argueta, you're here today because you're arrested on charge of battery, domestic violence. The court does find sufficient probable cause.
Señor Argueta, usted se encuentra aquí por un caso de agresión, violencia doméstica. El tribunal determina que existen indicios razonables.
Now, ma'am, you are the alleged victim in the case, and are you here because you don't want him to return home, or do you want him to return home?
Señora, usted es la presunta víctima en este caso. Usted se encuentra aquí porque usted no quiere que él regrese al hogar o porque usted desea que él regrese al hogar.
Que no regrese.
For him not to come back.
Okay. And so you don't want any contact at all with him?
Entonces usted no desea trato en absoluto con él.
No.
No.
All righty. So, Mr. Argueta, do you have another, well, first of all, ma'am, were you guys living together?
Señorita, ¿ustedes convivían?
Llegamos a convivir 2 meses y yo me fui de su casa y después él quería que yo volviera, pero no lo hice por su problema de alcohol y actitud y bipolaridad.
Well, we lived together for 2 months and then I left his house and he wanted me to move back in, but I didn't want to due to his issues with alcohol and that he deals with bipolarity.
All right, do you live at the 10645 Watertown Court address?
¿Usted vive en el 10645 Watertown Court?
Vivía.
I used to.
Okay, so he can go back to that address and there's no danger of you being there?
Entonces él puede regresar a esa dirección y no existe ningún peligro de que usted se encuentre allí.
Correcto.
Correct.
Okay. All right, so, Mr. Argueta, I'll set bond the amount of $500.
Señora, que te voy a programar la fianza en $500.
You are not to have any contact with Ms. Hernandez.
No se le permitirá el trato con la señorita Hernández.
You're not to possess any guns or weapons or any drugs or alcohol.
No se le permitirá portar armas de fuego, armas blancas, drogas o alcohol.
And I'll appoint a public defender to represent you.
Y voy a designar a las oficinas del defensor público para que lo representen.
All right, so ma'am, that means he can't have any contact with you if he calls you or has someone else call you, anything like that. That's contact, and that could result in a violation of his bond.
Señora, a él se le va a prohibir trato con usted, sea personalmente o mediante otra persona. Si lo intenta, lo hace, eso causaría un incumplimiento de la libertad bajo fianza.
Okay.
Do you have any questions
Okay.
about that?
¿Tiene usted alguna pregunta sobre eso, señorita?
No.
No.
Okay, thank you, ma'am. Any questions, Mr. Argueta?
Señor Argueta, ¿alguna pregunta?
All righty, thank you.
Gracias.
And
Your Honor, the interpreter can respectfully request the case number for this last defendant.
sure, it's, hold on a second, 2022 MM 8146AO.
Thank you, Your Honor.
I think that's it for the interpreters. Thanks.
Thank you, Your Honor. Have a good morning.
You too, bye-bye. Your name, sir? Mr. Brown, you're here today because you're arrested on charge of battery, domestic violence. I have read the charging affidavit, and I do find that there's sufficient probable cause. And you were living at the Park Road address, is that right?
That's in Canada, sir.
Oh, okay. The Broadway, that's a hotel then, huh?
Yes, sir.
Is Miss Spence still around?
Gone home, sir.
She's gone back to Canada? All right.
We were just dating, we're not together anymore. No,
Yeah.
no contact at all.
Perfect. And back in Canada, you don't live together?
No.
Okay. All right, I'll step on the amount of $500. You're not to have any contact with Karen Spence. You're to keep a separate residence from her. No guns, no weapons, no drugs, no alcohol. Did you want to have a lawyer appointed to represent you?
Yes, please.
I'll appoint a public defender, at this time. Keep in contact with them. And you can travel back to Canada as long as you keep in contact. Someone might have to go to Canada, take some depositions. Just saying. That's how it used to be. Your name, ma'am?
Tabitha Tabasa.
Hold on a second. Computer's about to crash. Yep. Well, may need the papers after all. All right, ma'am, you're here today because you were arrested on a charge of battery domestic violence. I have read the charging affidavit. You find that there's sufficient probable cause. And were you living at the Eleanor Drive address?
The address is,
1208 Eleanor Drive is where that's where you were arrested?
but it was the wrong one.
But is that where Jacob lives?
Yeah, but that's not, the address is at Pine Hills Road, not Illinois.
Okay, but you don't live with Jacob? All right. And if he's at Eleanor Drive, you have no reason to go back there?
My car is there.
I'm sorry?
My car is there. But I don't want to, I'll never, I'm not going to talk to him.
Okay.
I don't know how to get my car there.
All right, your car's still there, right, because you drove there. All right, well, you can go back there one time. I'll let you go back there one time, but you got to take law enforcement with you. You can't just show up yourself. All right, now, I can set a bond in your case, so you have to post a bond either with the county, where it would be a cash bond or a bondsman. Or you do qualify for pretrial release, which doesn't require a bond, but there are conditions that go along with that. Would you rather have a bond set, or do you want to be released pretrial release? Pretrial release? All right, I'll release your PTR. You're not to have any contact with Jacob Charles, no contact with him whatsoever. You're not to return to 1208 Eleanor Drive, except I will allow you to go back one time with law enforcement to pick up your vehicle, okay? You're not to possess any guns, no weapons, no drugs, no alcohol, and a weapon includes pocket knife. Can't have a pocket knife, okay? Not to have any of that stuff. I will appoint a public defender to represent you. All righty. Your name, sir?
Anthony Reginald Frederick Jr.
Hi, Mr. Frederick. You're here today because you're arrested on a charge of battery domestic violence. I have read the charging affidavit. I do find that there's sufficient probable cause. Do you have another address other than the Forest City Road address?
No, sir, I stay with my mom at the moment.
And where's that?
The Forest City Road, 7116 Forest City Road, apartment 47, Orlando, Florida, 328-110.
See, they have 7118, so that's not correct. It's
No,
7116.
it's 7116.
All right.
The address probably is 7118, but her address is 7116.
You have anywhere else to go?
No, sir.
And where does Ebony Laster live?
She stayed with her auntie in Richmond States.
That's not her address.
No.
So she came there,
Yeah, she
I
came.
guess, to deal with, you guys have sons together?
Yes, sir.
Okay.
5 and 4.
All right, you do qualify for pretrial release as well as a bond. I can set a bond, or I can release you with PTR conditions. Which one do you want?
The PTR condition.
All right, I'll release your PTR. You're not to have any contact with Ebony Laster, no contact whatsoever, okay? I will let you go back to the Forest City address because that's your mom's address. You're not to possess any guns or alcohol, no drugs, no weapons.
Okay.
And if DCF does get involved, you need to follow any kind of plan. It looks like they have been notified. You need to follow any plan or conditions that they put in place for your contact with your sons, all right?
I've got one more question. Will it be all right if I pick them up from school?
Not unless DCF says it's okay.
Okay.
All right, you got to check with them.
Okay.
All right? And again, as long as you have no contact with Ebony, and then I'll appoint a public defender to represent you.
Okay.
Okay?
Thank you.
Your name, sir? Go ahead.
Malachi
Last name?
Mercado.
All right, Mr. Mercado, are you here today because you were arrested on charge of battery domestic violence? I have read the charging affidavit, and I do find that there's sufficient probable cause. I think this was happening where you were living, right, at the Lake Point Village address, is that correct?
I think that's what the place is called. I'm
Is
not.
that where you got it? Okay. The address, though, that's where your mom and your stepdad live, or your dad?
That should be correct.
Yeah. Okay. So do you have another place to go other than there to live? Got friends, other family?
I could probably get into contact with somebody. Yes.
Because you're not going to be able to go back there for right now, since neither one of them are here, and I'm not going to allow you to have contact with them on the short term, okay? All right, I will set a bond amount of $500. I will order that you have no contact with Luis Mercado or with Jessica Mercado. She's a witness. No return to 5975 Lake Point Village, number 704. Can't go back there. Now, you can go there one time if you've got clothes or any items like that, but you have to call a police officer or a sheriff deputy to go with you. So you have to take law enforcement to pick up your items. Other than that, you're not allowed to go back there. You're not to have any contact with them. You're not to possess any drugs or weapons, no alcohol or firearms, okay? And I will appoint a public defender to represent you. All righty, thank you. Your name?
Marjorie Thomas.
Mr. Thomas, you're here today because you're arrested on charge of battery, domestic violence. I have read the charging affidavit. I do find that there is sufficient probable cause. And the address of 2614 Oscilla,
Yes, sir.
you weren't living there, right?
Yes, that's my place.
What's that?
It's my place.
Okay. And where does Angelique Heiss live?
She's like a roommate.
So she lives there too?
Yes, she's like a roommate.
All right, well, you can't go back there if she's there for right now. So I'm not gonna let you have contact with her for the time being, because she's not here to say she's okay with it. So you're not gonna be able to go there, you're gonna have to go somewhere else. You have another place to go?
No, sir.
Well, you're gonna have to find one. Either a hotel, or if you got a friend that can let you sleep on their couch, something like that, okay?
Yes, sir.
Okay. You do qualify for pretrial release, which means I can release you without a bond, but there are conditions. Got to stay, you got to follow up with your pretrial release officer, and there's things you got to do. But it won't cost you any money, and you can be released today. Is that what you want to do?
Yes, sir.
All right. I'll release a PTR. You'd have no contact with Angelique Heiss, and that's Heise. No return to 2614 Oscilla Court. You can go back there one time with law enforcement to pick up any items you may have, personal items, clothing, toiletries, things such as that. And you're not possessing any drugs, weapons, guns, or alcohol. And I'll appoint a public defender to represent you.
Your Honor, St. Pierre is mental health.
I will waive the appearance, Your Honor.
All right, he's got a couple of things. First of all, on the new offense, let's see. That was on a possession of methamphetamine, possession of cannabis, possession of drug paraphernalia. I do find the sufficient probable cause. And I'll stay the bonds as they were, 1,000, 100, 100. Want a public defender to represent him on those cases, on those charges. Now, they did an onsite on a VOP that looks like it's not a VOP anymore. Which one was it?
Is on the 18-15-225 or the 18-13?
I think it's the 15-225. Looks like he pled in front of Judge Davis, and it was revoke and terminate back in earlier this year.
1 second.
Let me see, let me make sure that's the one. No. Oh, no, that one is actually still active. There was a VOP, that one got dismissed because the state said that there wasn't sufficient information. So that one revoked the bond or that one would be no bond on site on that, on the 15225 AO. I think it's the next one.
36.
13619. It looks like he pled. Yeah, I pled on 1/5/2022, revoke and terminate probation. So that one's off. So there's release him on that. He shouldn't be held on that one. And then we have 2022 13843 AO. That's a warrant issued by the other Judge Jewett for a sale and delivery of cocaine. Bond is 5,000 on that. I'll state that as the same. That should be it, right? Is that all of them?
I believe so, yes.
All right. And appoint a public defender in all the cases. Okay. Your name, sir?
Soto Claudio, sir. Your Honor.
First name?
Jan.
All right, sir, you're here today because, first of all, you're arrested on a charge of grand theft third degree, possession of cocaine, and then 16 counts of possession of ammunition by convicted felon, 1 count of possession of firearm by convicted felon, 1 count of possession of firearm in the commission of a felony, and then finally a misdemeanor resisting without violence. I have read the charging affidavit, and I do find that there's sufficient probable cause. That's the grand theft, state the bond at 1,000, possession of cocaine 1,000, possession of firearm by convicted felon 4,000, and then on each of count 4 through count 20, which is the possession of ammunition by convicted felon, reduce those bonds to $100. Possession of firearm and commission of felony, $5,000, and resisting, reduce that to $100. And it will appoint a public defender to represent you on all of those charges. Now, there was one other and let's see, we did have, was there another charge for him?
There is an on-view VOP as well as a warrant VOP. They are
Okay.
the same case number.
Yeah, and on those 2 VOPs, there's no bond on those. Under violations. And a public defender will be appointed on the violations as well. So you got a PD in all your cases, okay? All right, your name?
Lorenzo Sparrow.
Mr. Sparrow, you're here for 2 things. First of all, you're here, get the new case. Looks like three things. That's a VOP, what's the petty theft? 699. Man, this computer's slow today.
Oh, man.
Such a crash. It's gonna get mad at me for saying that. Come on. Yeah, there it is. Okay, first of all, you're arrested on a charge of petty theft and trespass. I have reviewed the charging affidavit, and there is sufficient probable cause on those charges. The bond on the trespass is $250. The bond on the petty theft is $100, and I'll appoint a public defender to represent you on those charges. And you also have a violation of probation. You're currently on probation at that time.
Yes, sir.
And there is no bond on that, and I'll appoint a public defender to represent you on that violation of probation as well.
Is that it?
That's it. You're all set. At this point, no. They'll be set for an arraignment on the misdemeanor case, and then but your lawyer, keep in contact with the public defender. They'll know those dates. Okay. They'll make sure that it gets covered for you. Your name, sir? First of all, you're here because you're arrested on a new charge of possession of methamphetamine and resisting an officer without violence. I have read the charging affidavit. I do find there's sufficient probable cause. Say the bond of $1,000 on possession of methamphetamine, $100 on resisting without violence. And in addition, you're also here because you're on probation in 2020 CF 13432 AO and 2020 CF 14076 AO. And in both of those cases, your probation will be violated, and there's no bond on those, and I'll appoint a public defender to represent you. Who's this gentleman? Your name, sir?
Yes.
What was the last name?
Yeah. And the other one, I'll get the ASA.
Just wanted to make sure. That's what you had.
Thank you.
Mr. McNair is here, Your Honor, in case number 2022 MM7221AO. This one.
Okay.
We have reached a resolution with the state to resolve his case with as to count one, it's a withhold of adjudication, credit time served, and court costs. As to count two, I believe the state has agreed to null pros. And Mr. McNair would like to accept and enter a plea of no contest.
And the count three, did that not ever happen, or?
There was no count three.
Okay. Okay. All right, sir. Attorney indicates you wish to enter a plea of no contest to the resisting without violence and the false information. No, that's it. The resisting without violence. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
Yes, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes, sir.
Did you read over your plea form, understand the rights, and sign it on the bottom?
Yes, sir.
Any questions?
I do got one question. I got an out of state. Hold on, I'm trying to see what's the stipulation of that time. I done been in here 42 days.
You have to resolve.
I don't know, but now see this, and I think that's maybe one of the reasons why they want to get rid of this. I think now that this is cleared, then the clock will start running for whatever that out of state is for them to come and get you and let them know, okay? While you were being held on something else, they're not gonna have them come get you because you have to clear this up first, okay? All right, you didn't have any questions about the rights on this form? You understand this is punishable by up to a year in the county jail, up to $1,000 fine, and at the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
All right, do you find sufficient factual basis to accept your plea? I'll withhold adjudication since the time served, which is 42 days with 42 days credit. I'll impose court costs and a $50 cost of prosecution, and I'll give you 18 months to get that paid off. You can pay it a little at a time or all at once, as long as it's paid in the next 18 months. Okay? And it'll be released as to this case. State have an announcement as to count 2.
Yes, Your Honor. State announces a no pros as to count 2 on 22 MM 7221.
All righty, there you go. You're all set. 4:10 or 10:10.